All right, welcome everybody. My name is Ben Van Camp. I'm the Vice President at the Chamber Collaborative in Portsmouth, and we're delighted to have such a great group with us today. We have about 30 people that'll be joining us on the call today to hear about this great topic, which is, I think, our final event of 2020. So we snuck this one in here before the end of the year, and we're excited to do so. As we all know, hopefully vaccines are starting to hit our communities. I know folks at the hospital systems in Portsmouth and Exeter and Dover have all started receiving vaccinations, and hopefully soon enough that will roll out to a broader segment of the general public. With that comes a whole lot of questions for employers, right? And that's what we're here to talk about today. We're excited to partner with Sheehan, Phinney and Brian Bouchard there. To have what will be about a half-hour presentation with some time for questions and answers at the end. If you can, throw your questions in the chat. It's always a great way to keep things organized for us. And if you're not on mute, feel free to be on mute, because we all know who knows what happens if you're working from home like I am. So I'm just crossing my fingers right now myself. So with that, I'm going to introduce Brian. Had the opportunity to know Brian for a number of years through Leadership Seacoast, wonderful person, and I'm excited that he's going to be more active here on the Seacoast. So Brian is an attorney with Sheehan, Phinney, Best & Green. He counsels and represents companies through all manners of complexities, from claims involving discrimination, retaliation, and wage and hour violations, to questions involving employee management, executive contracts, employee mobility, and legal compliance. Brian will be based out of the Sheehan, Phinney Portsmouth office, which we're very excited about, starting in 2021. I know Brian's excited about that too, cut down on that commute. So without further ado, I'll let Brian take it over from here.
Thanks, Ben. Thank you everybody for joining us today. Let me just share my screen really quickly and get PowerPoint up. So thanks for coming. Happy to be rounding out the Chamber's year here, and thank you for the Chamber for hosting me here today. As Ben mentioned, right now I'm in Manchester, New Hampshire, but starting in 2021, you'll be able to find me at the firm's new office in Portsmouth, which we are extremely excited about. It's on the north side of the city at 75 Portsmouth Boulevard. So, you know, in the summertime, after everyone's vaccinated, stop by, say hello. We'd love to see you. Quick disclaimer for today's presentation. The presentation contains general advice and is no substitute for legal advice tailored to your specific circumstances. Please consult an attorney about your particular needs or situations based on what I'm going to say here today. So quick agenda. We've been getting a lot of questions here at the firm, mostly about three topics here. One, can the government mandate a vaccine for all citizens? What are the restrictions associated with the emergency use authorization that has been issued by the FDA? And what does the EEOC say as to what employers can do to require employees to vaccinate? So starting with a government mandate. There's no precedent on this subject for the federal government issuing a mandate for citizens to vaccinate. But doing so may not be constitutionally infirm based on prior cases, specifically one from 1905, we're going to talk about in a second. And essentially, it comes down to this, that the sovereign police powers of the federal government and the state have been found to supersede personal and religious liberties, particularly during, or probably only during, a state of public emergency. And the case is this, it's Jacobson versus Massachusetts. And the quick fact pattern, Massachusetts during a smallpox epidemic had required that its citizens vaccinate or they'll be fined. A Lutheran pastor refused the mandatory vaccination, refused to vaccinate, and he was fined excessive amounts. He took his case all the way to the Supreme Court of the United States, saying that his religious liberties and personal liberties and 14th Amendment rights have been violated. And the court came down on the side of Massachusetts, finding that the fines imposed were constitutionally sound. And effectively, the court said this: in every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand. Effectively, what that says is during times of crisis, one's personal and religious liberties can be subservient to the needs of the greater when you're dealing with a vaccination and with establishing herd immunity. New Hampshire, for its part, does have some precedent for mandating vaccinations, at least in certain industries. The New Hampshire statute RSA 151(9)B, which for this morning's purposes, we'll say covers healthcare industry generally. I know there's probably some healthcare attorneys in our firm here who may chide me on the generality of that statement, but it covers healthcare industries, and it requires employees of hospitals, residential care facilities, daycare facilities, and assisted living facilities to receive an annual influenza vaccine and to have a record of other immunizations, such as MMR and Hep C, except in cases involving a contraindication or sincerely held religious belief. So there is some precedent, at least here in New Hampshire, for industries to have a vaccination requirement yearly. And as the polls and data suggest, there is also perhaps reason that a government vaccine may be necessary, though perhaps unlikely. Recently, 2,000 polled firefighters in New York responded that only 55% of them would vaccinate. 48% of Black Americans have responded that they would not vaccinate, or that they would vaccinate, excuse me. And as of November 2020, only 58% of Americans responded that they would also vaccinate. Now, that number may have gone up a little bit given the success of the Pfizer and Moderna phase 3 testing that was wildly successful. But for herd immunity to be established here, we probably have to get to around a vaccination level of 70%. And it's viewed by some experts in the healthcare industry that tying vaccinations to employment is going to be an imperative for public health generally, because people are going to be more willing to vaccinate, frankly, if their employment depends on it. That raises some interesting questions, though. Right now, we are proceeding under an emergency use authorization from the FDA. And that confounds the idea of businesses and employers being able to mandate that their employees vaccinate. And I'm going to warn you that this is where things get a little complicated. So for an emergency use authorization to go forward, the Secretary of the Department of Health and Human Services has to attach required conditions to the authorization. And one of those conditions is that the person receiving the product for the emergency authorization, in this case, the vaccine, has the option or right to accept or refuse administration of the vaccine, and they have to be informed of the consequences that will follow from refusing the vaccine. Now, that's a statutorily mandated requirement. It can be waived by the President of the United States in the interest of national security. So far, the Trump administration has not done so, and the Office of the President-elect hasn't commented on this. The Pfizer emergency use authorization went forward, and the fact sheet published with that authorization says this: what if I decide I don't want to get the vaccine? The answer is, it is your choice to receive or not receive the vaccine. And so far, the Secretary of the Department of Health and Human Services has not approved any consequences for refusal of the vaccine, meaning that there's no indication here that businesses and employers will be able to mandate a vaccine because there hasn't been any approved consequences by the Secretary of the Department of Health and Human Services. So that raises sort of very broad legal questions and very specific ones as well. Can businesses require its customers to vaccinate? Think of airlines, think of universities, camps, cruise ships. I don't think anyone would want to board a cruise ship right now without knowing that most everybody on the cruise ship has vaccinated, and certainly the airline industry and the cruise ship industry would want to create such a mandate. But arguably, the Secretary of Health and Human Services, in granting the EUA, was required to establish whether private businesses may impose mandates and with what exceptions through the consequences disclosure. By not listing any consequences, it seems that it would be perhaps illegal for cruise ships, businesses, camps, whatever have you, to mandate that its patrons or its employees receive a vaccine. Conversely, it seems legally inconsistent for common carriers who have a duty to protect the safety of their customers and their patrons to be incapable of establishing a vaccine policy. I for one, am sort of the persuasion that, as a matter of administrative law, technical, that the Secretary of the Department of Health and Human Services, may not have the legal authority as granted from Congress to impose a mandate or to prohibit a mandate. But that's something that's going to have to be worked out in the courts in the short term, because the EUA will only apply here in the short term. Pfizer and Moderna will likely apply for, and they will receive full FDA approval, probably within 2021. The timeline on that is a little unclear, but certainly in the next year, unless something goes significantly wrong. So the idea of the Secretary of Health and Human Services not establishing any consequences and therefore maybe prohibiting businesses from mandating a vaccine is only going to last until full FDA approval is granted. Now, for its part, the EEOC has carved out a different path, and guidance published last week on the 16th expressly implies that employers may require employees to be vaccinated with the COVID-19 vaccine. Now, I want to be clear here, the EEOC has not come out and said directly that employers may require their employees to vaccinate. Rather, it has all but said that. If you read the guidance, it is quite clear that the EEOC is moving towards a situation where vaccinations may be required or will be required or allowed to be required by employers. But there's some conditions that will attach to that vaccine. So for those on the call or the webinar who are unfamiliar with the ADA process for medical inquiries and medical exams, I'm going to go through it a little bit because some of the EEOC guidance hinges on knowledge of that. So there are three situations that the ADA covers with respect to medical inquiries and medical exams. One is a pre-employment phase, the other is a post-offer pre-employment phase, and the third one is a during active employment phase. So when someone is applying for a job in that pre-employment phase, the only thing the employer can ask is, can you perform the essential functions of this job with or without a reasonable accommodation? That's it. That's as far as the inquiry can go. In a post-offer pre-employment phase, which is when the offer of employment has been made, but the person hasn't started working yet, and it's known that the position itself requires the employee to pass a fitness for duty exam, for example. During that phase, the post-offer pre-employment phase, employers have wide latitude to require medical exams, such as a fitness for duty exam, and to ask medical inquiries of the employee without violating the ADA. Once someone has become employed, that latitude narrows significantly. And during employment, an employer can only ask a medical inquiry or can only mandate a medical exam if the inquiry and exam are job related and consistent with a business necessity. So let's think of an example of what that may include. One might be a manufacturer is changing its processing or operational procedure, and it's now required that employees have to be able to lift 50 pounds in order to perform the essential functions of their job. That's a situation where asking whether someone can lift 50 pounds is job related and consistent with a business necessity. Another situation might be where a company is introducing a new computer program, and the computer program has as a warning that those individuals with epilepsy, shouldn't use this program because they may experience an episode. That's a situation where an inquiry may be allowed because it is job related and consistent with a business necessity. Back to the vaccines now. The EEOC has come out and said that the vaccine is not considered a medical exam. It has also said that inquiring whether an employee has been vaccinated is not a medical inquiry. And that's important here. Because the EEOC has said that the vaccine is not a medical exam and that even asking whether someone has been vaccinated is not a medical inquiry, employers do not have to show a job-related or business necessity reason for requiring someone to vaccinate or to ask or for asking whether someone has been vaccinated. okay? But you need to be careful. While you don't have to show a business necessity for asking whether someone has been vaccinated or for requiring the vaccine, pre-screening questionnaires may actually violate the ADA law on medical inquiries, and it does so like this. If you are asking an employee as part of a pre-screening questionnaire whether or not they have a contraindication that may prohibit them from receiving a vaccine, that itself is a medical inquiry. And while you are allowed to ask whether an employee has been vaccinated, asking an employee why an employee has not received vaccination, that may spell trouble here. Similarly, in order to actually even receive the vaccine, the healthcare provider has to ask the employee a series of questions to identify whether or not the employee is someone who, perhaps for medical reasons, should not receive the vaccine. That pre-vaccination inquiry is itself a medical inquiry under the ADA and can only be asked if the inquiry is job-related and consistent with a business necessity. So while requiring a vaccine is not considered a medical exam, the inquiry that has to be asked as recommended by the CDA and as required by the EUA approval is itself a medical inquiry that employers need to be careful about because it has to be job related and consistent with a business necessity. Don't worry, there is a workaround to this, okay? Two solutions. One solution is to implement a voluntary vaccination program as opposed to a mandatory vaccination program. Under that situation, the employee who is being asked this pre-screening question wouldn't be forfeiting their job for declining a vaccine. The second is to mandate vaccinations through a third-party vendor, not under contract with the employer. So what the ADA says is that an employer or the employer's agent can't ask questions that would be considered a medical inquiry unless they're related to the job and consistent with a business necessity. By sort of farming this work out to a pharmacy, for instance, or to another healthcare provider, the employer is able to skirt around that requirement in the law. So if you're going to have a vaccination program that's mandatory as an employer, I would recommend having a pharmacy perform that work. It's okay if the pharmacy then bills the employer. The employer can pick up the bill. That's okay. But I would be cautious about having, for instance, a clinic where you hire a company to come into your place of work and to administer vaccines. Because in that situation, you're under contract with the clinic. They're coming to your place of employment, and they're going to have to ask questions that are considered medical inquiries, which makes the entire vaccine have to be job-related and consistent with a business necessity. Now, even though the EEOC is permitting employers to mandate vaccines, there's a few carve-outs that we have to talk about. One is that there is an exemption for sincerely held religious beliefs. Those of you on the call who are in the HR profession, I'm sure are familiar with Title VII. It prohibits discrimination on a number of bases, including sexual orientation, gender, religion, ethnicity, race. But there is one part of it that actually imposes an affirmative obligation on an employer. And that is when an employee who has a sincerely held religious belief can't do a certain part of a job because of that religious belief, the employer has to offer a reasonable accommodation to the employee. Now, the employer is only obligated to offer that accommodation unless it would impose an undue hardship on the company. And that's very similar to the ADA standard, where a reasonable accommodation has to be offered unless the accommodation would impose an undue hardship on the business or the company itself. The only difference here in Title VII is that the undue hardship standard is significantly lower than the undue hardship standard under the ADA. Here in Title VII, the undue hardship standard is anything more than a de minimis burden on the employer is going to be considered an undue hardship. Conversely, The ADA says that an undue hardship is an action requiring significant difficulty or expense. So importantly, religion is broadly defined under Title VII. It includes traditionally recognized religions such as Christianity, Islam, Judaism, Hinduism, Buddhism, but also includes beliefs that are new, are uncommon, or not part of a formal church. Atheism, for instance, is considered a religion under Title VII that would have to be accommodated by an employer. Social, political, and economic philosophies or personal preferences are not considered religious beliefs. Most times there isn't cause to question whether an employee has a sincerely held religious belief. You just, most of the time, accept it. However, you are permitted as an employer to make probing inquiries if you have bona fide doubt about the sincerity of someone's religiously held belief. And so here's what we need to look for in that context. Specifically, if you're a company that mandates a vaccine and an employee is coming to you and saying, well, I'm refusing the vaccine, I'm refusing this mandatory protocol here because I have a sincerely held religious belief, and you have bona fide doubts about that belief. Well, in order to make further inquiries into the employee's belief, a couple factors have to happen here. The employee has to have behaved in a manner that's markedly different or inconsistent with the professed belief. So if someone's coming to you and saying, my religion doesn't allow me to be vaccinated, but you know that they receive a flu shot every year, well, then you may have cause to probe their sincerely held religious beliefs. The other factors here, which aren't as relevant to a vaccine context, but I'll go through them anyway, are whether the accommodation sought is particularly desirable benefit that is likely to be sought for secular reasons. That may apply to a vaccine, particularly only with 58% of Americans saying that they would volunteer to be vaccinated. Whether the timing of the request renders it suspect. Most of the time that pops up in a situation where an employee wants the Sabbath off, for instance, because it's a Saturday and they don't want to work on a Saturday. They'd rather be out with their friends, or any other reason to suspect that the employee doesn't have a sincerely held religious belief. But if there is one, then the employer may have to accommodate the employee. And to do so, you would just go through the normal accommodation analysis that you would go through under the ADA for a disability. Go through the interactive process with the employee, and try to find an accommodation that would allow them not to be vaccinated, but still perform the essential functions of their job in light of the sincerely held religious belief that they have. There's also an ADA component to a mandatory vaccination program. Under the ADA, employers are authorized to impose as a qualification standard that any individual shall not impose a direct threat to the health safety of the individuals in the workplace. That includes other employees in the workplace, that includes third-party contractors, that includes customers that may visit your workplace. If an employee declines to vaccinate due to a contraindication or a disability, an employer needs to make an individualized assessment as to whether or not that employee will pose a direct threat to the workplace in light of the fact that they are declining to vaccinate because of a contraindication or because of an underlying disability. And so there's 4 factors that you need to consider in identifying whether someone poses a direct threat risk. One is the duration of the risk, the nature and severity of potential harm, the likelihood that the potential harm will occur, and the imminence of the potential harm. When you're dealing with a vaccination here, what you really need to look at is, okay, where is this person working in our workplace such that they may pose a direct threat? If you have a nurse, for instance, who is visiting patients in the ICU, that person is likely going to pose a direct threat by not being vaccinated to the patients with whom she is visiting, or even to other members of the employment staff. If she's interacting with anyone at a nurse's station and she's not vaccinated or he's not vaccinated, they may infect someone else who then goes and visits with a patient in the ICU unit. However, if someone is working in an administrative office building as part of a hospital and that office building has no connection with patients, it may be a different situation where the employee is not posing a direct threat either to other employees or to patients of the hospital. But even assuming that you go through this analysis and you find that an employee is presenting a direct threat to others in the business because of their refusal to vaccinate, doesn't mean that you're permitted to terminate them. Rather, you have to go through an accommodation analysis and ascertain whether a reasonable accommodation exists, not one that would impose an undue hardship, that would eliminate or reduce the perceived direct threat risk that you have just identified. So some of the accommodations you may consider here are masks, teleworking, which I think almost everyone's been doing already, having an isolated workstation, or some type of position reassignment. If you get to the end of the reasonable accommodation analysis and you find that there's no accommodation that the employer can offer that will eliminate the direct threat posed by the employee because they can't vaccinate because of a disability or contraindication, or even because of religious belief, then under that circumstance, and only that circumstance, can you move forward as an employer with some type of disciplinary action or some type of termination associated with the employee not receiving the COVID-19 vaccine as part of your company's mandatory protocol. And we're going to wrap up here with sort of a overarching summary and some guidance. So to be clear, the EEOC has not taken the position expressly that companies may offer or may require employees to vaccinate. But when you read between the lines of the guidance, that's pretty much what they're saying, is that you as a company, as an employer, can require your employees to vaccinate. I think the reason the EEOC hasn't come out and made a clear statement, a perfectly clear statement on this, is because of the complications we saw earlier with the EUA, the Emergency Use Authorization, and the conditions that are attached to it, including the right of the person receiving the vaccine not to be vaccinated. If you are going to have a mandatory vaccination protocol, I would recommend that you farm that work out. Otherwise, the mandatory inquiry that has to be asked of the person receiving the vaccine to identify whether or not they medically should receive it is going to be considered a medical inquiry. And because it's going to be considered a medical inquiry, that sort of transforms the vaccine into a medical exam, in which it would not otherwise be considered one by the EEOC. So some practical guidance going forward: be flexible with your employees on vaccinations, participate in the interactive process in good faith, update your policies. This isn't necessarily associated with this presentation, but the universal guidelines in New Hampshire require employers to train their employees on the universal guidelines themselves. Maintain confidentiality of all medical records. So if you have a list of those people who have been vaccinated and those people who have not been vaccinated, that is considered a medical record under the ADA that has to be kept separate in a different file from the employee's personnel file, and should be secure. And finally, avoid medical inquiries when asking about employee vaccination. It's fine to ask whether an employee has been vaccinated. Asking why an employee has not been vaccinated may spell trouble for you. And if there's any questions, happy to.
Yeah, Brian, there was one that came through from Amy Can about maybe an incentive to encourage people to vaccinate. So perhaps like a $200 incentive to encourage employees to vaccinate.
I don't see any problems with that. There's certainly nothing in the EUA that would spell trouble there. The only thing that would give me pause is if you have someone with a disability, for instance, and they're unable to vaccinate. Are they not receiving the benefit of their employment because they have a disability? That's the only thing that would give me concern, but an incentive certainly wouldn't be a problem under the EUA. Other questions?
That was the only one in the chat. I don't know if anyone else on the call wants to maybe unmute and ask a question or throw it in the chat real quick, but not looking like it. So you must have you eliminated. Maybe Joe has a question from Star Island.
Yes, thanks. Sorry. First of all, thanks for the excellent presentation. I found it very helpful. I'm wondering if mandating of testing follows the same pattern as what you just described with vaccination. Thank you.
Mandating that an employee receive a COVID-19 test before coming into work? Yeah.
Yes, that's correct.
Yeah, the EEOC did publish guidance on this. And that has also not been considered an exam or a medical inquiry. So it's fine to require that they receive testing to identify whether or not they pose a direct threat to anyone else in the workplace.
Thank you very much.
Okay. If there's any other questions, my contact information is below. Feel free to reach out, give me a call, send me an email, and I'll help you out where I can.
Thanks, Brian.
Thanks, Brian. Really.
Is that Astrid? Thanks, Astrid.
Thank you, Brian.
All right. Well, thank you, Brian, on behalf of the chamber and everybody else. I wish everybody happy holidays and a great new year. And stay safe out there. Wear those masks. Take care.
Happy
Thanks all.
holidays.
Happy holidays.